require any help, kindly let me know. I'll be there.
Sure.
Okay.
Okay, both teams here. That's TC 03 and 06.
Yes, sir. Both the teams are here.
Okay, can we begin then?
Yeah. Sure.
Can I get the time allotments of the speakers?
Am I audible?
Yeah, we can hear you.
Yes. From the petitioners, both speakers will have 40 minutes each and 2 minutes for rebuttals.
And respondents?
The respondents, speaker 1 will be taking the time of 13 minutes. Speaker 2 will be taking the time of 15 minutes, and the rest 2 minutes will be kept for the sir rebuttals.
Okay, both teams ready to start? I mean, Aditya, are you ready?
Yes, let's go ahead.
Okay, so team 03, speaker 1, whenever you're ready, you can go ahead.
For permission to approach the bench.
Yeah, granted.
Much obliged. The council would like to collectively address the bench as your lordships.
Yeah.
Much obliged, your lordship. The case for Honorable High Court of Limbo is Dr. Banerjee versus State of Limbo and others. The council seeks permission to move on to the statement of jurisdiction if the lordships are aware of the facts.
Yeah, you can proceed to the jurisdiction.
Much obliged. The petitioners have filed the petition under Article 226 of the Constitution. It is humbly submitted that this Honorable High Court has jurisdiction to entertain matters as stated under Article 226 of the Constitution of Limbo, that states, notwithstanding any article in 32 Clause 2, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue any person or authority, including in appropriate cases, any government within those territories directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose.
Okay, counsel. So since you mentioned that the writ is being filed seeking certain writ remedies, what is the writ that you have sought in this case?
Your lordship, we have sought for the writ of mandamus, that is to repeal the amendment that has been made to the Constitution, to the Patents Act of Limbo.
Okay. And besides that, are there any other remedies?
There is also evoking the writ of certiorari to correct the amendment that has been made.
So you're basically saying you want to correct it and you want to repeal it.
No, your lordship. I apologize. I beg your pardon. The amendment has to be repealed.
Repealed. Okay. So certiorari will not arise.
No, your lordship.
Okay. And any other remedies? There is something about cancellation and something else I see in your prayer.
Your lordship, can I address that issue after when we come to the prayer?
Okay, fair enough.
Much obliged, your lordship. Does the honorable bench want a brief of statement of facts?
No, you can proceed to your issues, but before that, please tell us who is the petitioner in this case. Who are you representing? Because earlier you said the petitioners. So are they two people or is this one petitioner?
I beg your pardon, your lordship. I just meant the petitioner. I got.
Okay, so
It-
who
it
is the
was-
petitioner? Who is the petitioner in this case?
The petitioner in this case is Dr. Banerjee, who is representing Savita as her legal guardian, as he's the founder of the orphanage in which Savita resides in.
He's not a major, counsel.
I'm sorry, Your Lordship, you weren't audible.
Is she a major?
No, Your Lordship, she is of 15 years. She's 15 years old. So she's a minor.
So can a minor file a writ petition?
Dr. Banerjee is representing Savita. So yes, the writ petition can be filed, Your Lordship.
But you need to represent in a certain capacity. So in what capacity is he representing her?
Your Lordship, we'd like some time to address the question.
Okay, maybe your researcher can work on it while you proceed with the arguments.
Much obliged, Your Lordship. Thank you.
Okay.
Your Lordship.
One more. Sorry to interrupt you, counsel. One more last question. Is Drishti a party in this case?
No, Your Lordship. Drishti is a lawyer who is and is not a party in this case.
Okay. So fine. Okay, fine, counsel. You can proceed to your issues.
Okay. Your Lordships, there are 4 issues, out of which the first 2 will be addressed by co-counsel 1, and co-counsel 2 will address the 3rd and 4th issue during her speech.
Okay.
Counsel seeks permission to move on to the first issue.
Aditya, you're okay? Can we go ahead?
Go ahead, let's go ahead.
Yeah.
Much obliged, Your Lordships. The first issue is that whether the amendment to Limbo Patents Act 1970, National Ethical Guidelines for Biomedical and Health Research on Human Participants, and National Guidelines for Stem Cell Research is unconstitutional. The counsel, on behalf of the petitioner, respectfully submits that the uninformed investigation of experimenting with blood samples of Savita and genetically engineering upon genes is violative of her right to privacy, which is a part of the basic structure of the Constitution of India. It is humbly submitted that the amendment made to Limbo Patents Act 1970 clearly violates the basic structure doctrine of the Constitution of Limbo, as upheld by the Apex Court in Keshavananda Bharati versus State of Kerala. To summarize the judgment quoted in the memo, the Honorable Supreme Court stated that even though the Parliament under Article 368 has the power to amend the Constitution, it cannot alter or destroy the basic structure and the framework of the Constitution. The Council humbly submits to that the Honorable Supreme Court of India held that the right to privacy is a fundamental right flowing from the right to life and personal liberty, as well as other fundamental rights securing individual liberty and in the Constitution.
How is the basic structure affected, counsel? It's just an amendment.
Your Lordship, the amendment is affecting the right to privacy of the individual, that is Savita and the other children in the orphanage. So it is a direct attack on the right to privacy and right to life.
You can take an injunction from a competent court with regard to that.
Your Lordship, under Article 226, under Article Your Lordship, can I have a minute, please? Yeah, be much obliged. Yes, Your Lordship, under Article 226, the High Court has the power to enforce its writs to correct any violation of rights. So the petitioner has approached this honorable court.
I don't see any violation, counsel. You can go before the civil court and get an injunction.
Your Lordship, by making the genetic details of Savita public information, there has been a right to privacy, which will be addressed in the further arguments. If the Lordship allows me to.
This is a jurisdictional issue. If I have to, you have to convince me on the jurisdiction. How is there a violation? I see there's only legal right, which can be cured by the civil court.
Your Lordship, I feel your question will be answered in my further arguments.
Okay.
Much obliged, Your Lordship. So as I was saying, the Council humbly states that the Honorable Supreme Court of India or of Limbo held that the right to privacy is a fundamental right flowing from right to life and personal liberty, as well as other fundamental rights. The right recognizes the fact that all information about a person is fundamentally his or her own, and they are free to communicate or retain it to themselves. The core of informational privacy thus is the right to autonomy and self-determination in respect of one's personal data. Article 21 of the Constitution of Limbo states that no person shall be deprived of his life and personal liberty except according to the procedure established by law. In Ramjet Malani versus Union of India, the Supreme Court dealt with the right to privacy elaborately and held as under. Right to privacy is an integral part of life. The right to privacy is also recognized as basic human right under Article 12 of the Universal Declaration of Human Rights Act 1948, which states as follows: no one shall be subjected to arbitrary interference with their privacy, family, home, or correspondence, not to attack upon his honor and reputation. Everyone has the right to protection of law against such interference or attack.
Exactly,
And
that is
Counsel-
my question, Counsel. What I asked you is that your remedy is before the civil court. I don't see any fundamental right being infringed here. You're not addressed that fact.
Your Lordship, in the second paragraph, I have mentioned that right to privacy is a major part of right to personal liberty and life. So this act of leaking the genetic information and is a direct attack on Savita's and the other children of the orphanage's personal liberty, right to
Right,
personal.
Counsel. I get you. There is a leak of information, but how is that? Why should we utilize our powers under 226? You're not answering that question. What can be done under CPC? Why should we declare this? Why should we issue a writ of mandamus?
Yeah, I think what my brother judge is trying to say is, if there's an alternate remedy, then how is the writ maintainable?
Your Lordships, can I have some time to answer the question?
Okay, that is one aspect. The second aspect is, Counsel, didn't Savita herself go and sign up for these trials? So hasn't she gone and voluntarily agreed that whatever, I mean, she's given her sample, they have taken the test, they've done the test, all those things have happened. So that being said, now, how can you say that a right to privacy is involved?
Your Lordship, I will be addressing that under the second issue, but if the Lordship wants, I can go to it right now.
Okay, no, do you have any other submissions on this issue? I think we're running out of time, so quickly summarize and then go on to the next issue on these aspects.
Yes, sure, Your Lordship, much obliged. Quoting the above authorities, the Council argues that this amendment is unconstitutional, violating the Article 21, Part 3 of the Indian Constitution, specifically the right to privacy under it. The Council would like to move on to the second issue.
Okay.
The second issue is that whether the vaccine trials conducted on Savita were legal at all. So due to the sensitivity around the research involving children, Limbo Commission of Medical Research notes that children usually lack the capacity to provide informed consent, and the authority to allow a child's participation in in research rests with parents or guardians, who must provide their permission. In children between the ages of 13 and 18, written assent must be obtained. Orphan Savita, being a minor, as per the above definition, needed to possess a guardian's consent for her vaccine trial to Orange Enterprises. Hence, the Council contends that the vaccine trial held on Savita were illegal per se, and also humbly submits that the Orange Enterprises failed to follow the guidelines of LCMR. The Council also points out that the Orange Enterprises was at grave medical negligence by administering a heavy dose of COVID vaccine, which could have brought the petitioner under grave medical illness. Hence, the Council pleads medical negligence compensation for Savita too, which would be a societal good.
No, but didn't it result in them finding a cure? Finding the vaccine. So isn't that in the larger public interest? Isn't that if you weigh or outweigh the two sort of aspects, don't you think that public interest here is the bigger aspect? And since you were able to save so many more people with this vaccine, it's all right if we maybe disregard Savita's rights at this stage.
Your Lordship, nevertheless, the the very act of having done a research or an experiment on a minor without the consent of a guardian is illegal in the first place.
No, but were there any adverse effects?
Your Lordship, the COVID vaccine, which is known to be very fatal to whoever is infected, and Savita was put under the threat of losing her life. So,
No, but she didn't die. She's still alive. So how is that? How does that apply?
Your Lordship, the fact that Savita didn't die is only due to the genetic mutation in her DNA, which is a very non-natural fact, because that exists because of the experiments done by Dr. Banerjee in the first
No,
place. So
did she give her consent to Dr. Banerjee to do those experiments initially?
no, she was born because of the experiments, Your Lordship.
No, correct. So here is Dr. Banerjee who's representing her interests, who has already done certain experiments on all these children, and I mean, would per se has done some illegal experiments on them, using them basically as test subjects. So that being said, could we say that Dr. Banerjee has the best interest of Savita at hand when he filed this petition? It looks more like a personal issue that he's trying to urge here through her.
Nevertheless, Your Lordship, Dr. Banerjee made sure that he takes care of all the children, and so he does have Savita's best interest. And
but hasn't he withdrawn the support to the orphanage? I mean, Aditya, am I right? He's withdrawn his financial support, right?
That is true. And
Yeah.
considering your financial prayer, I see there's a personal motive rather than any financial loss that's taking place to the petitioner.
Lordship, the financial support we have pleaded for is to Savita and not Dr. Banerjee. So the Dr. Banerjee is acting as her legal guardian, and he's representing her.
I don't see the reason why we should give you a compensation.
Yeah, he's your client. I mean, he hasn't instructed you as to what he proposes to do. If he's withdrawn his financial support, obviously he has no interest in those children or the orphanage.
Your Lordship, the financial support had to be withdrawn out of necessity to fund the case. So that
so it would appear that you're charging him exorbitant fees.
Council will do one thing. We will ask the legal services authority to take over the case. Let the state represent the petitioner.
Your Lordship, but state is one of the parties which is held at the wrong in this case.
No, they'll appoint a counsel. They'll appoint a counsel who can represent, who's probably charge him, who not charge him or reduce the charges, and then maybe he can then support financially.
So do you have any objection for an amicus to be appointed? Amicus curiae?
Your Lordship, I beg your pardon. I'm not aware of the term. Could you please elaborate?
No, yeah. Sorry, sir. Go ahead.
Considering that there is financial troubles to the petitioner, we will appoint an advocate on behalf of the petitioner, who will not cost the petitioner in terms of legal fees.
Lordship, I think that would take more time to do that, and I guess we move on with the arguments and get to a conclusion as soon as possible, so that there is a compensation to the affected individual.
All right.
Yeah, okay, counsel. Quickly summarize issue number 2.
Your Lordship, I am done with the 2 issues I was dealing with. I seek your permission for co-counselor 2 to take over the next 2 arguments and the prayer.
Sure.
Much obliged, Your Lordship.
Is speaker 2 here? Okay, I think you have to unmute yourself, counsel.
You can unmute TC03.
Am I audible?
Yeah, we can hear you.
The council seeks permission to the bench to be addressed collectively.
Sure.
The council will now be speaking with reference to issue 3 and issue 4, if the bench permits.
Yeah, please proceed, Counsel.
Issue 3 is with reference to the issuance of the writ of mandamus. Now, Article 23 of the Constitution empowers the High Courts to issue to any person, including the government.
Article 23, is it?
I'm sorry, Your Lordship.
You said Article 23.
226, I'm so sorry.
Okay.
May I proceed?
Yeah, please.
Including the government in appropriate cases, directions, orders, or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, or any of them under its original jurisdiction. Mandamus is a writ issued by the court to compel the performance of a particular lower court or a governmental authority to correct a prior action or a failure of an act. The Learned Counsel hereby pleads this honorable court to issue the writ of mandamus directing the Registrar of Patents of India of Limbo to immediately cancel the patent granted to Orange Enterprises and also the license obtained to manufacture the Provid immunity medication, considering the fact that the genetic extraction itself is illegal per se, as mentioned by my counsel. In the case, so the Supreme Court, in the case of the Comptroller and the Auditor General versus K.S. Jagannathan and another, the Supreme Court held that there is no doubt that the High Courts in India exercising their jurisdiction under Article 26 have the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions where the court or public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statute or a rule or a policy decision of the government.
Counsel, what were the facts in that case? How does it apply here?
May I have a moment to structure my argument?
Okay, you read that case?
Not wholly, Your Lordship.
Okay, so now you've cited that case. Is it binding on us?
In the nature that the Supreme Court has mentioned it, it is binding on.
No, maybe, but is there any specific provision in the Constitution which says that law laid down by the Supreme Court is binding on subordinate courts?
I'm sorry.
No, is there a specific provision in the Constitution of Limbo which says that law laid down by the Supreme Court is binding on subordinate courts?
Yes, Your Lordship.
What is that article?
May I have a moment to answer?
Okay, maybe a researcher can help you. Let her look for it.
Yeah, can we proceed with the case?
Yeah.
Thank you, Your Lordship. Moving on, we also have the bench comprising of M.V. Muralidharan, which held that on grounds of extraordinary and emergency situations, courts can grant the writ of mandamus for which the petitioner has appealed under Article 226 of the Constitution. According to Section 6 of the Indian Patents Act, revocation of a patent in public interest. So where the central government is of the opinion that a patent or the mode in which it is exercised is mischievous to the state or generally prejudiced to the public, it may, after giving the patentee an opportunity to be heard, make a declaration to that effect in the official gazette, and thereupon the patent shall be deemed to be revoked. Here, we can talk about how the president of the state, Tanmay Siddharth, had in view, as soon as the elections, the future elections were coming up, the amendments were made, and this would serve his needs at the moment. So in that sense, we can say that the revocation of the patent is in order, Your Lordship.
But who has authority to revoke?
Section are you referring to, Counsel?
That wasn't audible, Your Lordship. May the point.
Section are you referring to? Did you say Section 6?
Section 66 of the Patents Act.
Okay. You said Section 6. So Section 6 is not something related to what you said.
I'm so sorry, Your Lordship. My connection is a little bad, so my audio might be glitching a little.
No. You said 6 specifically, Counsel.
I'm so sorry. I would like to make a clarification and say that Section 66 of the Indian Limbo Patents Act.
Go ahead.
Okay, so that being said, who has authority to revoke the patents?
In this case, it would be the Registrar of Patents, Your Lordship.
So did you all approach him before coming here?
Your Lordship, had are directing the court, asking the court for permission to.
No, so why should we grant you permission? You have every right to go and approach him. So you could have gone and done that before coming here. Because you're saying Mandamus. So if you're saying Mandamus, we would presume that you've gone and he's not complied or he's not cooperated. So if you haven't gone at all, when is the question of a Mandamus?
Maybe have a moment to answer this question, and then we'll talk about the issues first, and then answer the question.
But that is the principle of this issue, right? I mean, that's the key aspect. If there's an alternate remedy, then your writ is not maintainable.
Noted, Your Lordship.
Okay, you may have your moment, but what else do you have on this issue?
Yes, Your Lordship. So in subsection 3C of the the Limbo Patents Act, the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living thing, substance occurring in nature, is not an invention. Here we're talking about the genome of a person. So this is a naturally occurring, it's a living thing. We're referring to a living person here. So in that sense, genes are found in situ, are not patentable to claim an isolated as an may I restructure it? I'm so sorry, I messed up.
No worries, take your time.
So sorry. Yes, Your Lordship. Thus, merely isolated naturally occurring genes are considered a discovery and not an invention. Also, we can say that in 3C of the Act, the absence of any clear information about recombination in these molecules. I'm so sorry, Your Lordship. May I have a moment to answer?
No, so just tell us in simple terms. When you're saying you want the patent cancelled, firstly, on what basis? Which is the law that says it's permissible? And I mean, how does that relate to the facts of this case?
Your Lordship, firstly, the fact that there was a genetic extraction made illegal according to the laws of the land before the amendment was brought into Limbo Patents Act. Other than that, we also have to say that there is, under the Patents Act, a patent is given when there is a new invention. So here we're talking about genes, a naturally occurring substance. Other than the fact that it is illegal to extract genes from a person, genes itself wouldn't, using genes to create this vaccination itself does not become a new invention. So in that sense, we say that.
No, but they have
consented to this, Council.
I'm sorry, Your Lordship, I did not hear that.
Your party, the petitioner, consented to this.
She signed up a
gene instruction.
Your Lordship, it must be noted that Savita was a minor and she did not have the consent of her legal guardian, that is Dr. Banerjee. So her consent shouldn't be considered here because of the fact that she is a minor.
Yeah, but okay. We are still not convinced. See, this whole patent is helping the world at large. Now, why it has to be cancelled?
Duly noted that it is helping the world at large, Your Lordship, but at the cost of an individual's right to privacy. Someone's right has been violated here without her consent, Your Lordship.
But those are two different things, isn't it? Isn't it two different things, Council?
May the Council be enlightened in what way?
One, yes. See, with regard to your privacy aspect, yes, is one aspect. The one is with regard to, because the world here is suffering at large. So the vaccine also is quite necessary. So as a court, we are responsible to protecting the constitutional rights of so many people. Isn't right to health of other people also be considered by this honorable court?
Your Lordship, but the right to health of this minor also should be considered, as well as her privacy should be considered in this case, because again, her consent was not given. We cannot take that her consent was given largely because of the fact that she's a minor.
Continue, Constance.
We would like to, if your lordships are satisfied with the argument, we would like to move on to the fourth issue.
Yeah, you can proceed.
Yes. These are the charges in charges of defamation. The issues are in relation to the charges of defamation. May I proceed?
Yeah, proceed.
While reporting, the journalists are expected to be careful and cautious. In case of grievance, ventilated by individuals on ground that certain defamatory statements are made by publication in the newspapers, reputation of the concerned aggrieved parties on one hand, and the freedom of press on the other have to be equally balanced. In a case, Salennadan Desi versus Gajala Mala Reddy, the Andhra Pradesh High Court awarding compensation by way of damages to a tune of rupees 10,000 to the plaintiff said that the journalists were expected to be careful and cautious while proceeding to make publications. Recording a statement of fact as reflected by record, the court said, was something different from making a publication giving exaggerated versions with several deviations and improvements. Such reporting, the court said, would virtually reduce the true episode to its lowest bottom. For that reason, and at that stage, the public might not be able to draw any distinction between the portion which might be true and the portion which might be untrue. Reporting of distorted and deviated versions with comments without proper verification of facts might not fall within the umbrella of protective journalism, the court ruled. Such defamatory statements made in publication.
Can you define defamation, concept?
The court said could not. I'm sorry, Your Lordship.
Can you define defamation?
May I have a moment, Your Lordship? Defamation, Your Lordship, is any time when the reputation of a person has been tarnished. This is when it is publicated.
How is your reputation harmed here?
The reputation of Savita was harmed here when several media bodies of the media were reporting about her special condition and talking about how her genetically mutated blood was designed so that the world could be taken over. And there was also a tag given to the whole community of the orphanage, calling them nature's odd springs instead of nature's offsprings. In this sense, they were defamed. May I proceed, Your Lordships?
Isn't that prove that their genetics are different than the others?
Yes, Your Lordship. The point here is that the media reported it in such a way that they were harmful to society, which is not true at all.
No, but you're saying society was harmed, but you're saying the reputation of the orphans was affected. So how does that? I mean, how
no,
does that
Your Lordship, I meant the community of the people within the orphanage is what I meant.
But the other orphans aren't complaining. Only Savita is complaining.
Your Lordship, the orphanage itself, Nature's Offsprings, was termed as Nature's Odd Springs. Savita was the oldest there. It makes sense for her to be the shoe, and she was.
But she's still a minor.
The orphanage? How can you?
It also. I'm sorry, I didn't know.
Isn't that reference to the orphanage, and orphanage has to
file the petition.
Yeah.
Yes, Your Lordship, but in the case, the orphanage derived that name in the first place because of the orphans that were in question there. So.
No, but you said there is truth in what is published because their blood was genetically mutated.
I'm sorry.
Isn't truth a defense for defamation? So in this case, if there is some truth in what was published, then how do you say there's any defamation that is?
There was no truth in what was published. It was firstly Nature's Offsprings was portrayed in such a way where they were a they were harmful to society, which is not true at all.
So by someone calling you odd, you feel defamed.
No, Your Lord. There was also a point mentioned in the facts that they were going to take over the world and things like that. I can't quote exact
Yeah, para 13. Yeah.
along those lines.
So by taking over the world, you consider that being defamed.
They were looked at badly, Your Lordship. So in that sense, their reputation was tarnished by the public. They were
Okay,
looked.
so okay, is there any precedent where something similar has happened in the past, and the High Court has stepped in and granted compensation?
I'm sorry, Your Lordship.
No, see, now to assess the quantum of compensation, it would require a certain amount of evidence to see what the extent of damage is. Now, can the High Court, in exercising power under 226, look into evidence to assess the quantum of compensation to be awarded?
The council would like a moment to answer.
I think you're running out of time, Counsel. So
Or can we answer after I've made all my points?
yeah, you can answer in your rebuttal.
Yeah, all right.
You please summarize now. I think time is running out.
Yeah. So we'd like to, for all of the reasons stated above, one, because of the defamation that was caused to Savita, as well as the legality of the patent itself, we'd like to proceed to the prayer, Your Lordship.
And how much compensation are you expecting? How much compensation in terms of money are you expecting?
It's left to the discretion of the court, Your Lordship.
No, but we need some ballpark figure for sort of award if you're inclined. You didn't give this any thought.
I'm sorry, Your Lordship.
You didn't give this any thought before filing the petition. How much compensation you're expecting?
We thought it would be best for the court to decide upon this, Your Lordship.
Okay, Counsel, proceed to your prayer.
May I start, Your Lordship?
Yeah, sure.
Wherefore, in the light of the issues raised, arguments advanced, and the authorities cited, it is humbly prayed that this honorable court may be pleased to 1. Kindly declare that the amendment allowing extraction and exploitation of any part of the human genome is unconstitutional, being in violation of the fundamental right to privacy guaranteed under the Constitution. Issue 2. Kindly issue the writ of Mandamus, directing the Registrar of Patents to immediately cancel the patent granted to Orange for PIM. 3. Kindly issue the cancellation of the compulsory license granted by the government of Limbo in respect of PIM. And 4, kindly issue the writ of Mandamus directing the Ministry of Broadcasting and the Ministry of Information Technology to issue appropriate orders to restrain anyone from reporting about the private life and medical condition of Savita or anyone at her orphanage.
Ministry of Broadcasting a party before this court?
I'm sorry, Your Lordship?
Is Ministry of Broadcasting party before this court?
No, Your Lordship.
So can you grant relief against a non-party?
We pray for the court to direct them to do so under Mandamus, Your Lordship.
No, but they're not before us. So how do we direct them?
Under Mandamus, we pray that the court should, as they are a government agency, and they are inferior to the court, we believe that the court has.
Okay, because I think your time is run out, so we hear the next theme.
All right, thank you, Your Lordship.
Thank you, Counsel.
Your Lordship, is the Council of Respondent audible?
Yes.
Yeah, we can hear you.
The Council solicits to begin, Your Lordship.
Yeah, please proceed.
Indeed, Your Lordship. The Council seeks to address the bench collectively as Your Lordship. Much obliged, Your Lordship. May I please this Honorable Court? This is the Council appearing on behalf of the respondent in the instant case, Ms. Drishti versus State of Limbo. Would Your Lordships appreciate a brief perusal of the facts and case in hand?
Not required, Council. I think you can proceed to your issues or to the jurisdiction.
Much obliged, Your Lordship. The council here, on behalf of the respondent, shall seek apologies as under the first issue, subclause 1. There has been a typological error due to the misinterpretation of the facts, but now that the council is aware about the actual facts, council most humbly seeks pardon and would request to consider only second sub-issue under the issue 1.
Okay, Council.
Much obliged, Your Lordship. The council most humbly pleads that the amendment made to Limbo Patents Act 1970 is valid and the guidelines being mentioned by the amendment are reasonable. To point out precisely, the paragraph 10 in the Moot proposition clearly mentions that the amendment to the Limbo Patents Act 1970 was made along with certain guidelines of the Limbo Council for Medical Research, which allowed the patenting of extraction of human gene, along with legalizing the process of modifying the human DNA, which is constitutional and reasonable on the grounds of public health interest, and this was intended to protect the people at large from the highly infectious disease named COVID, which was causing high fatality rates among all the nations, including the state of Limbo. If the amendment wouldn't have been made to the Patents Act 1970, all the manufacturing activities for the production of PIM would come to halt, which would not only cause a great panic and furor and send the world back to the stage where there was no known cure or protection against the COVID. Here, the maxim salus populi, which means the health, welfare, good, salvation, and felicity of a people should be of a supreme law. This was upheld by the US State High Court, wherein it said that individual rights sinks in the necessity to provide for the public good. And this law is a supreme lex law of all countries in all the countries.
Council, sorry to interrupt you, Council. Just one question. Who do you represent in this case? Who are the respondents?
The respondents in the state of Limbo, Your Lordship.
Only one respondent. So Orange is not a party here, and neither is the ministry and.
They come under the ambit, Your Lordship, but we are representing the whole state of Limbo.
Ambit of what?
The ministry comes under the ambit of the state of Limbo, Your Lordship.
Which provision says that?
Indeed, Your Lordship, the council seeks pardon. I'm not aware of that.
Okay, so now that's with regard to the ministry. Now, what about Orange, which is the company involved?
It is not a party we are representing, Your Lordship.
Earlier they said when you need to seek revocation of a patent, you need to hear the patent holder as well. So if Orange is not a party here, then how do we proceed in the matter?
Indeed, Your Lordship, but then we are here representing the state of Limbo and the governmental body of Ministry of Broadcasting.
So what you're saying is you're not concerned with what happens to Orange or the ministry. You're only focused on what happens to the state.
No, Your Lordship, that was not what the council meant.
Okay, Council, proceed.
Much obliged, Your Lordship. The Article 47 of the Constitution of Limbo, being a directive principle, states and also directs the state, saying that it's the primary duty of the state to work towards improving the public health. As the right to health, being a part and parcel of right to life, it is a fundamental right guaranteed to every citizen of a Limbo under Article 21. Henceforth, the patent granted to Orange Enterprises is valid on the similar grounds of public interest. Your Lordship, the council seeks permission to cite cases which are not being mentioned in the minute.
No, you can cite them, no problem.
Much obliged, Your Lordship. In the case State of Punjab and others versus Mohinder Singh Chawla, the apex court reaffirmed that the right to health is a fundamental right to life, and it should be put on a record that the government had a constitutional obligation to provide health services. Also in the case of State of Punjab versus Ram Ludhaya Bhaiya, the court went to endorse, saying that the state's responsibility to maintain the health services at large. So the government here states that the public interest weighed much heavier than the interest of any individual or any community or a group of people for the matter at times when there was a very existence of humanity was at stake. And all the considerations must have been made in a way of public interest and for the protection of rights of humanity as a whole. There is no fault with the amendment, and there is very much necessary to keep in law in sync with the continuing paradigms and technological advancements.
Counsel, firstly, those two cases you cited, are they binding on us?
Indeed, Your Lordship.
I mean, which provision says so?
Article 141 of Constitution of Limbo 1950 says that Supreme Court's law declared by the Supreme Court are binding on all the other courts in India.
Okay, good. Okay. Now you also cited an American judgment earlier.
Your Lordship, it is not a judgment. It was a magazine which was being used, which is being used.
So is there any provision that says international covenants or international treaties are binding domestic?
Indeed, Your Lordship, the council please pardon.
Which provision is that?
The council please pardon, Your Lordship. The council is not aware of the fact.
Okay, it's Article 253. You can look it up later.
Much obliged.
Okay, now coming back to the amendment, what is the nature of the amendment? How did the government bring about this amendment?
Your Lordship, when there was an outbreak of infectious disease named COVID, there was no known cure around.
No, that is those are the reasons. But in what manner was this amendment passed? Like, what did they pass a law? Did they pass some a notification or an order? What was it?
The amendment was made to the Patents Act, and later on there were guidelines which were issued under the Limbo Council Medical Research, stating that they allowed patenting of recombinant human DNA and also legalized the process of recombinant human DNA.
Counsel, do you have the fact sheet before you?
Indeed, Your Lordship.
Yeah, can you please go to paragraph 11?
Yes, Your Lord. Indeed,
the second line there. Please read the second line. And immediately.
Tanmay Siddharth's government passed an order notifying compulsory.
So stop there. So he passed an order. Now, what is this order? How can you amend something by an order?
Your Lordship, the issue of compulsory license is being dealt by my co-counsel, and I shall be dealing with the issue of writ of mandamus to direct not to cancel the patent.
Okay, fine. So she'll be answering this question.
Indeed, Your Lordship.
Okay, counsel. What other arguments do you have?
I shall be proceeding to the second issue, Your Lordship. Whether the issuance of writ of mandamus directing the registrar for the cancellation of patent granted to Orange Enterprise is valid or not. The counsel for respondent here humbly submits the cancellation of patent granted to Orange Enterprise is not valid. When a writ petition is filed under Article 226 of Constitution, the High Courts are vested with the rights to issue writs, including the writ of mandamus, for the enforcement of fundamental rights. But it is also observed this is a preeminently public law remedy and is not generally available against private wrongs. It is used for the enforcement of various rights of publics or to compel a public authority to discharge their duties and act within the bounds. But in this case, the petitioners are asking for a writ to be issued for cancellation of patent against a private entity. But writ of mandamus cannot be issued against a private body. Hence, in such cases, petitioners must have a locus standi to do so by demonstrating that there is a legal wrong which is done to him or her by the violation of their right, and therefore, being an aggrieved person, has the right to file the writ petitions. And
this thing they are asking the state to cancel it. They're not.
No, the registrar.
Yeah, the registrar to cancel it.
Indeed, Your Lordship, they are asking the registrar to cancel it, but they are filing a writ of mandamus under the High Court for the cancellation of patent and asking the High Court, the Honorable High Court of Limbo, to direct the registrar.
Do we have the powers to do it?
Indeed, yes, Your Lord.
So then, what's wrong in exercising it?
But then there is no infringement of a right to privacy of Savita, Your Lordship. Hence, the petitioners are asking for a writ which is issued, which is not valid.
So does that justify doing trials on a minor and mutating of blood and things like that? Isn't that an infringement of a right to privacy?
Indeed, no, Your Lordship. What the government did was in the purview of a public health at large, when there was a stake of public health being questioned, the government acted in good faith to just provide a cure for the disease and help the people out there.
So what does the government do according to you? What is the act of the government to sort of for the well-being of the people?
Your Lordship, the government are entitled to provide public health for every person in the country or the state they are residing. Not only the individual's private interest or infringement of individuals' right to privacy infringement is taken into consideration.
No, we are aware. We are aware of that concept. We are aware of that. But what does the government do in this case to further that goal?
Pardon, Your Lordship. Could you?
No. How did your government try and fulfill that requirement of providing public health to everyone? What do they do specifically?
Indeed, Your Lordship, the government made amendments to the Patents Act, which allowed for legalizing the process of recombinant DNA, which helped the Orange Enterprises in order to produce PIN.
Council, this is a state government, is it?
Yes, indeed, Your Lordship.
Okay, now are you aware of the 7th schedule?
Indeed, Your Lordship.
So that contains the list, union list, state list, and concurrent list. If you look at, do you have the constitution before you?
Indeed, Your Lordship.
Yeah, please go to the 7th schedule. You have it, Council? Yeah. The list 1, union list. Yeah, look at entry number 49. Did you get it?
Indeed, Your Lordship.
What does it say?
Patents, inventions, and designs, copyrights, trademarks, and merchandise marks.
Yeah, exactly. So this comes under the union list, which means only the union government can create law or pass legislation in respect of this subject. Now that being said, prima facie, it looks like your state government had no part to bring out this amendment. How do you justify this?
Indeed, Your Lordship, but then the public health aspect is being covered under the state list, which the government acted in a good faith, but
Which entry of the state list?
6, Your Lordship.
6.
Public health and sanitation, hospitals and dispensaries.
So okay, so if it's a public health issue, then how do you relate that to a patent? You're saying a patent comes under public health?
No, Your Lordship. Here the government acted by amending the Patents Act by allowing the Orange Enterprises to produce the vaccine.
Correct. So patent is a union list subject, 49. So then how would you say it comes under the purview of the state list?
Indeed, Your Lordship, it doesn't come under the purview of state list, but then the government.
So do you concede that the state government had no part to bring out this amendment?
The council would seek pardon, Your Lordship. I'm not aware of that.
Okay, council. Any other arguments?
Indeed, Your Lordship. So here in the case, it is humbly submitted that it is only when there is an alternative and constructive remedy available for the applicant, he or she should be aware of pursuing the remedy before invoking the special jurisdiction in the High Court of Limbo to issue a prerogative writ of mandamus. This writ is known as extraordinary writ because it is only issued when there is alternative remedies have been exhausted. But the petitioners directly approached the Honorable Court of Limbo before addressing the alternative remedial mechanism. It was held the rule of exhaustion exists so that a person is not allowed to circumvent existing statutory proceedings by approaching the High Court under Article 226. Thus, the appellant seeking mandamus here must show that the demand justice from the authority concerned by performing the duty and the demand was refused. The demand must be made to a proper authority and not to any authority which is not in a position to perform its duty in manner demanded. Therefore, in the instant case, there was no statutory redressal mechanism which was being followed by the petitioners in the first place, and they directly filed the PIL to the High Court of Limbo before instituting to any of the inferior courts which also had the jurisdiction to try this petition. Henceforth, the issuance of the writ of mandamus for cancellation of patent granted to the Orange Enterprise is not valid, Your Lordship.
No, is this case a PIL?
Indeed, Your Lordship, the petitioner said it is a PIL. I mean, they mentioned it.
I mean, I don't know. I don't think they said so, but anyway, just clarify that in the rebut.
Indeed, Your Lordship.
Okay. Any other submissions, counsel? I think your time is running out.
Indeed, no, Your Lordship. Now my co-counsel will be dealing with issues 3 and 4.
Okay, Aditya, you have any more questions for counsel number 1?
No.
Okay, counsel. Thank you. We'll hear your co-counsel.
Thank you, Your Lordship.
Greetings to the respected bench and my fellow members of the bar. Am I audible?
Yes.
Yeah, counsel, we can hear you.
This is counsel number. Pardon, Your Lordships. Greetings to the respected bench and my fellow members of the bar. Am I audible now?
Yes.
This is counsel number 2 on behalf of the respondents and will be addressing the issue 3 and 4. Your Lordships, the counsel seeks permission to please the bench with the arguments.
Proceed, counsel, please.
The first contention this council will be addressing is, should the compulsory license granted by the government of Limbo for the production of probate immunity medication be cancelled? And the second contention is, if the issuance of writ of Mandamus directing the Ministry of Broadcasting and Ministry of Information Technology to issue appropriate orders to restrain anyone from reporting about the private life and medical condition of Savita or anyone at her orphanage and directing to take down all the published content is valid or not. Your Lordships, the Council humbly submits that the compulsory license for the further production of probate immunity medication by the pharmaceutical companies granted by the government of Limbo is valid because in times when the very existence of humanity is at stake and the cure for the infectious disease that's probate is finally found, its further production must definitely be encouraged. Your Lordships, if we look onto the very meaning of the word patent, it is an exclusive right granted for an invention. The government had brought an amendment to the Limbo Patents Act 1970, which allowed patenting of recombinant human DNA. Further, the government of Limbo passed an order notifying compulsory license for PIM under Section 92A of the Patents Act 1970. Your Lordships, the Section 92 of the Limbo Patents Act 1970 says, if the government is of the opinion that there exists a national emergency or in circumstances of extreme urgency or in case of public non-commercial use, a compulsory license should be granted. Your Lordships, the outbreak of probate and infectious disease with a high fatality rate spreading all over the world was definitely a health urgency. Thus, according to Section 92 of the Limbo Patents Act 1970, the government of Limbo was indeed right in granting the compulsory license. Further, Clause 1 of Section 92A of Limbo Patents Act 1970 says, compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health problems. Your Lordship, since the PIM, a pharmaceutical product, was patented as stated by Section 92A, there does not arise the question of cancelling the compulsory license granted by the government of Limbo.
Counsel, what is the procedure to grant a compulsory license?
Your
What is
Lordship,
the procedure?
Your
What is the
Lordship, the
procedure?
government-
What is what is the procedure and who grants it?
Your Lordship, the government grants it. Government cannot pass any order notifying compulsory licenses except during the national emergencies and urgent situations.
But who decides if it's a national emergency or an emergency situation?
The government, Your Lordship.
So isn't that giving the government arbitrary power to do whatever they want?
Indeed, no, Your Lordships.
Because you also read further, 92A says that the government can also export it to other countries. Right?
Yes, Your Lordships.
So in this case, it looks like your government only wanted to grant a compulsory license so they can export it to other countries and not really benefit their own people.
Indeed, no, Your Lordships. The Section 92A states that it can export to any country having insufficient or no manufacturing capacity in the pharmaceutical sector. Since PIM was the only vaccine available at the time for the infectious disease, it was indeed right in granting the compulsory license, Your Lordships.
You're saying your government is justified in granting compulsory license as long as, and they can also export it to other countries.
Indeed, your lordships.
So isn't there some profit motive in your let's say in your act?
Indeed, not your lordships. It was only to address the public health problems.
No, but which public?
The,
It looks like you're helping. You're looking at addressing the public health of other countries rather than your own country,
including the state of limbo and the other countries, your lordships.
Does it say so? 92. 92 says only for export purposes. Please read 92 again. 92A. I'm sorry.
Compulsory license shall be available for manufacture and export of patented pharmaceutical products to any country or the pharmaceutical sector for the concerned health problems.
Correct. So it says only for export purposes to other countries, you can give a license under 92A.
Your lordships, the section 92 of the Limbo Patents Act states that if the government is of the opinion that there exists a national emergency, it can grant the national emergency or any urgency, it can grant the
No, but your
license.
government has granted it under 92A specifically, Council. That's what 11 para 11 of the fact sheet says so. That's an act of your own government. So now how can you say it comes under 92 and try and take shelter under 92?
Your lordships, the PIM was cannot be just restricted to the state of limbo because as it is a matter of public concern, it definitely should be exported to the other countries, your lordships.
So the purpose was to export, not to help your own country.
Indeed, no, your lordships.
Okay, we have our reservations on that, but is there anything else you want to say, Council?
On this issue, yes, a small concluding statement, your lordships.
Okay.
May I proceed?
No, I'm sorry, Council. I'm sorry. One last question. Your co-counsel said that you would highlight or enlighten the bench as to the nature of this amendment. What was the act or what was the nature of the law that was passed?
Apologies, your lordships. The council is not aware of this.
No, the fact sheet says a government order was passed. So what is this government order? Could you enlighten us on that?
Indeed, your lordships.
That's para 11, second line of the fact sheet.
Tanmay Siddha's government passed an order notifying compulsory license for PIM.
Correct. So now with the government order, can you amend a law?
Indeed, yes, your lordships.
Which provision says so?
Apologies to lordships, the council is not aware of.
So you're saying yes without any backing.
And yet again, there needs to be clarification as to which is the respondent. Is it the state government or the central government? That is yet to be clarified.
The state of limbo, your lordships.
So the state.
Is it the union government or the state government?
The state government, your lordships.
So do you agree that the state government has power to legislate on the union list subject?
Apologies, your lordships. It's actually the union government. The state of limbo. Limbo is a country, your lordships, or a state.
Are you sure?
Indeed, your lordships.
So you're saying it's a country?
Limbo is a state, your lordships. State as defined by Article 12 of the Indian Constitution, your lordships. Of the Limbo Constitution.
No, because if you say it's a state, then your argument of your co-counsel that it comes under public health and is a union list subject will or a state list subject will not help her then.
Pardon, your lordships?
No. Your co-counsel had argued that since it comes under public health, it's a stateless subject. So now if you say it's a center or a union government, that will take away her argument. So be very careful.
Apologies, your lordships. The council is not aware of the right fact.
Okay, council. Any other submissions, council, on this issue? Or you can proceed to the next issue. Yeah. Summarize this issue and proceed to the next one.
Indeed, your lordships. Your lordships, granting of the compulsory license made the PIM cheaper so that all the sections of the society could afford it and at the same time also opened up revenue streams for state. It also ensured timely procurement and distribution of vaccines aiming at the cure of COVID at the earliest. Your Lordship, since the compulsory license was granted to the patented pharmaceutical product, it wasn't in violation of any laws and hence need not be cancelled. Your Lordships, the Council seeks permission to proceed with the next issue.
Proceed, Council.
Your Lordships, the Council humbly submits that the issuance of writ of Mandamus directing the Ministry of Broadcasting and Ministry of Information Technology to issue appropriate orders to restrain anyone from reporting about the private life and medical condition of Savita or anyone at her orphanage and directing to take down all the published content is invalid because Article 226 of the Constitution of Limbo gives power to the High Court to issue writs in case of breach of fundamental rights of any citizen by the state. But in the case of Ms. Drishti versus State of Limbo, no fundamental rights of the petitioner has been violated. In fact, your Lordships, issuance of writ of Mandamus directing the Ministry of Broadcasting to take down all the published content would be violative of Clause 1 of Article 19 of the Constitution of Limbo. The words secure to all its citizens the liberty of thought, expression, belief, faith, and worship of the preamble indicates that Constitution of Limbo implicitly includes freedom of press. Freedom of press falls within the purview of liberty of thought and expression. Therefore,
Is that an absolute right? Is it an absolute right? Aren't there some restrictions that can be imposed?
Indeed, yes, your Lordships.
Now they're saying that they have alleged that there's defamatory content published by you all. You're called the orphans, nature's odd springs, and things like that. So how do you justify all those acts by your media?
Your Lordships, in the case of Drishti versus Government of Limbo, the fundamental principle which was involved in freedom of press is the people's right to know, because of which the media monitored and reported the issues happening in and around Savita, as they were in light of the vaccine discovered for COVID, and hence the public had the right to know, your Lordships.
But what is the right to know? You're saying that they're going to take over the world and things like that. Are you justified in saying things like that?
Indeed, no, your Lordships.
So then, do you agree there's some defamatory content?
Indeed, no, your Lordships. Because the press has the right to hold the opinions, your Lordships.
So an opinion should be a right one. You can't simply, in the guise of saying an opinion, quote something defamatory or something that's incorrect.
Indeed, your Lordships.
So you're saying that the government will pay compensation to them?
Indeed, no, your Lordships.
Why not?
Because the the information published was the information published was the right of the freedom of press, your Lordships.
No, so the freedom of press is there, I agree, but it's not an absolute power. I mean, there are certain restrictions. Okay, what are the restrictions under the Constitution with regard to freedom of the press?
Your Lordship, can I take a moment?
Yeah, okay. And also, are you aware of any recent landmark judgment on the freedom of the press?
Indeed, yes, your Lordships.
Which judgment is that?
Landmark judgment? No, I'm not aware of the landmark judgment.
Any judgment on freedom of press? Any recent judgment?
Indeed, yes, your Lordships.
So tell us.
In the case of Ramesh Thapar versus State of Madras, your Lordships, where the Supreme Court held that the freedom of in this case, the petitioner was a printer, publisher, and editor of a journal, and under section 9(1)(a) of the Madras Maintenance of Public Order Act 1949, the entry and circulation of this journal was banned in the erstwhile state of Madras.
Okay.
Which in response to the ban, the petitioner filed a writ petition before the Supreme Court, averring that the powers under the Act were an excessive restriction on freedom of expression under Article 19 of the Constitution of Limbo.
Yeah, so there they curtailed his right to publish or even circulate his journal. Here we're not curtailing that right. We're merely saying don't publish incorrect information, don't publish defamatory information. So how does that case help you?
Your Lordships, in the case of Union of India versus Association for Democratic Reforms, it held that one-sided information, disinformation, misinformation, and non-information all equally create an uninformed citizenry, which makes democracy a farce, Your Lordships. Freedom of speech and expression includes right to impart and receive information, which includes freedom to hold opinions. Therefore, the news published by the media in the state of limbo was exercising their right under Article 19, Your Lordships.
Okay, Counsel. Anything else, Counsel?
Indeed, yes, Your Lordships.
Yeah. Quickly summarize. I think you're running out of time.
Or Your Lordships. Your Lordships, in the case of Express Newspaper versus Union of India, the Honorable Supreme Court held that the courts have duty to uphold the freedom of press and invalidate all laws and administrative actions that abridge that freedom. Freedom of press has three essential elements. They are freedom of access to all sources of information, freedom of publication, freedom of circulation. So the media in the state of limbo, as held by the Honorable Supreme Court, gathered the information, published and circulated it. Your Lordships, in the present case, the press acted as a medium of availing knowledge and spreading the vital information of events, developments, incidents with regards to national interest, Your Lordships. Moreover, citizens are solely dependent on media and press as they have no other means to gather information due to the imposition of lockdown to curb the effects of COVID. Your Lordship's right to freedom of speech and expression carries with it right to publish and circulate one's ideas, opinions, and other views with complete freedom and by resorting to all available means of publication.
Counsel,
the right
you
to
run out of
freedom of
time.
the
Counsel, sorry to interrupt. You've run out of time. We'll give you 1 more minute to quickly summarize. Can you summarize in 1
Your
minute?
Lordships, here the various sections of media were just exercising their right guaranteed under Article 19 with the light of public interest, not violating any right of Savita, Your Lordships. Your Lordships, if the bench is pleased with the arguments, the Council would now like to proceed with a prayer.
Go ahead.
Wherefore, in light of the facts stated, arguments advanced, and authorities cited, the counsels for the respondent most humbly pray and implore before this honorable court to quash the writs filed by the petitioner and pass any order which the court may deem fit in light of justice, equity, and good conscience. It was an absolute honor argument before this bench, Your Lordships.
You want us to quash the writ?
I mean to dismiss the writ, Your Lordships.
Okay. Okay, Aditya, do you have any other questions?
I think rebuttals, they can go ahead with rebuttals.
Yeah, fine. So I think 2 minutes was reserved. So yeah, petitioner's counsel, whoever's doing the rebuttals you got 2 minutes.
Your Lordships?
No, petitioner's counsel
apologies.
can proceed. Yeah.
No, apologies, Your Lordships, for misinterpretation of the facts during the arguments. It is the union of limbo as we mentioned it under the Constitution of Limbo, and thus this now allows to make amendment to the Limbo Patent Act 1970, Your Lordships, as you had asked me to answer for this in the end.
Where does this say union?
Your Lordships?
No, where did you get the word union from?
As it is said as the Constitution of Limbo, Your Lordships.
So you're saying a state can't have a constitution?
Your Lordships, the Council is not aware of this fact, Your Lordships.
Okay, counsel, I think
The
we hear the
state
rebuttals
definitely-
now.
Indeed, Your Lordships.
Okay, petitioner's counsel, who's doing the rebuttals, 1 or 2?
Your Lordship.
To Your
Yeah.
Lordship.
Okay. Yeah, counsel. Whenever you're ready, you can proceed. You have 2 minutes.
Yes, Your Lordship. Lordship, before I begin the rebuttals, I'd like to answer the question that you asked me based on about how the Supreme Court has power, if the Supreme Court has binding powers. Under Article 144, the law declared by the Supreme Court shall be binding on all courts within the territory of India.
144.
141. I am so sorry.
Okay, counsel. Okay.
I would like to proceed with the rebuttals.
Yeah, they said it to the PIL. So do you agree?
No, Your Lordship.
Okay. Other rebuttals?
The respondent said that the patent is in public interest, and later they defined that patent as giving an individual or a company exclusive license over an invention. Making the production of PIM exclusive is in no way of public interest, as it is obviously it will reduce the volume at which the medications will be produced. They also mentioned that the directive principles is not enforceable. They also The directive principles of state policy are not enforceable, Your Lordship. That is also something we'd like to point out.
Okay.
And also that does the amendment fulfill the test of reasonableness as mentioned under Article 14, Your Lordship? These will be our rebuttals.
Okay. And the last thing they said was that the press had freedom. Do you have anything to say on that? They said that there is freedom of the press, they can publish, and the citizens have a right to know.
Very true that the citizens do have a right to know, Your Lordship, but when the truth has been blown out of proportion to this extent, I think the question of freedom of press is highly compromised here.
Okay. Anything else? You're done with the rebuttals? Okay, so rebuttals, please.
The council seeks permission to proceed, Your Lordship.
Yeah, please proceed.
The first contention is, Your Lordship, the petitioners mentioned that Dr. Banerjee is representing Savita, and he's a legal guardian of Savita, and he's representing Savita, but he's just funding the orphanage where she resides. And in the petition also, they were actually filed by Miss Drishti, who was representing Savita through the orphanage, which is explicitly mentioned under the para 16 of the Moot proposition. The second contention is petitioners themselves were in dilemma whether they have the jurisdiction to file the writ under the Honorable High Court under Article 226, Your Lordship. And also they couldn't prove that there was an infringement of right to privacy as they have alternative remedies available for Savita, for the addresses. And also the clinical trials didn't cause any of the threat to the life of Savita because they followed due care. And also the Banerjee himself had done illegal experiments on Savita, and the children, which is in first place made her being born as specially able, which was illegal, and also had withdrawn his financial fundings to the orphanage, Your Lordship. So how can he represents Savita in a goodwill in conferring her interest, Your Lordship? The fourth one is, they said the contradictory and ambiguous statements saying that only Savita was complaining about the infringement and defamation, and also stating that she was the eldest, as she was the eldest among all the children who were in the orphanage, she was alone can say about that. That wasn't understandable, Your Lordship. The sixth one is the Orange Enterprises themselves in the paragraph 19 have mentioned that they'll unconditionally apology and compensate her, and also Savita took money which was given by the company for volunteering in the clinical trials in the first place, Your Lordship. So how can they seek for the compensation now again? They also said that the Ministry of Broadcasting is not a party to the petition, but they want you to grant a relief when they are not even brought under in front of the Honorable High Court of Limbo, Your Lordships.
But would there be a functionality of the state under Article 12?
Your Lordship, you weren't.
No, would the ministry come under Article 12 being a functionality of the state and therefore be under the purview of the state of the union of the state of Limbo, and hence an order can be passed against them?
Indeed, the council says it yes, Your Lordship. It might come under the purview.
Okay, council, thank you. Aditya, do you have any other questions?
No, Arjun. No.
Okay, is someone from the organizing committee here?
Yes, sir.
Yeah.
I would like to bring to your notice that our Honorable Principal and Chairman Suresh V. Nadagowda sir has joined the meeting. We welcome you, sir. And sir, if you do not.
Sir.
How are you, Rigo and Aditya?
Doing well.
Thanks so much.
Yeah, very nice to see you both. I hear the arguments, and I also congratulate all the participants in this intro mood and those who have made it to final. Result is we awaited, it seems. Huh?
Yes, sir. Yeah. Thank you so much. I mean, it was a pleasure judging the rounds, and always good to be back at ULC, even if it's virtual.
Good. Yeah. If it were a normal situation, you would have made a visit to UL.
Yes, sir. Yes, sir. Yeah.
Sir, we wouldn't have missed that opportunity, sir.
Yes, sir.
Yeah.
But
Okay.
congratulations to you too, sir,
So-
and the organizing committee. It's been a great job. They've done a great job with the organizing of Moot, and it'll definitely
Yes.
help the first and second years at least learn the nuances of mooting, and probably they'll be able to take part in inter-college events further.
Yeah. So we are only facilitators. So it is
Right.
all being arranged by students only. As usual,
Right.
our students are very good in all these activities.
Yeah, very true.
So
sir,
even
very
when
true.
you were in the college, huh?
Yes, sir.
So
Yes.
even online also, we have been doing all our activities.
Okay.
And in fact, in the last 2 years in the pandemic, we have been more active compared to all other law colleges in Karnataka as well as in India.
Right.
So
sir,
we
right.
have arranged a series of special lecture series inviting eminent judges, advocates, and all that. So you might be that even we had Indra Jaising, Palin Nariman, something. Yeah, then Justice Santosh Indran, almost everyone have addressed our students.
Right.
So in that way, we have been very active, and pandemic have not been a hindrance for our activities.
Okay, sir. Okay, no, that's good to know.
Yeah.
And thank you so much for having us again.
Yes, sir.
Yeah, good. So how are you, Aditya? What are the things going on?
Doing well, sir. Doing well, sir.
Very good. How is dad? Convey my regards to him.
Surely, sir. I will do that.
Okay. Right then, go ahead. Huh? Just I logged in just to say hello to you all and congratulate the students.
Thank you so much, sir.
Yeah, thank you, sir.
Okay, Rigo. Yeah, be in touch. Huh?
Yes,
Thank
sir.
you.
Sure.
Right.
Thank you again, sir. Sir, if the judges are okay, can you give feedback to the participants regarding how the moot went on?